First of all, welcome to Jenner and Block, and welcome to Southern Poverty Law Center and the American Constitution Society. We got an exciting, well, I don't know, exciting. We got a very important panel on a very important case, we're seeing challenges to our democracy in many forms, and this is certainly one of them. So I'm not going to. It's such an important conversation that I want to get right to it. So with that, I want to welcome our distinguished panelists and kick it over to Pema.
Thank you very much. Thank you. Hi, everyone. My name is Pema Levy. I'm a reporter at Mother Jones Magazine. I've been covering voting rights in the Supreme Court for a while now. I also write about politics and democracy issues, so I really feel like everything is kind of coming together in this case. I also kind of just want to jump right into it, so I'm actually not going to read all of the remarks I prepared. But I will just say that this case is a big deal. It hasn't been getting quite as much attention as some of the others, but I think that it really should. I'm going to quote one of the amicus briefs in this case, that if Alabama wins this case, it would enable most states to substantially reduce their numbers of minority opportunity districts without violating Section 2. That's a lot of legalese that we're going to cover. If they occurred, these cuts would be the first of this magnitude since the end of Reconstruction. So that's just sort of setting the historical framework for our discussion today. But I think I want to turn it over to the panel to describe this case and get into the details. I'm going to start with Brad. Good thing you're sitting next to me because I was planning on starting with you.
Okay.
Can you give us a description of this case and how we got here? And if you have time, can you talk a little bit about Section 2 and vote dilution? And the role that has played in uplifting communities for the last 50 years.
Okay, I'll try to cover all of that. That's why.
And by the way, you have like 5 or 10 minutes.
Okay.
Talk quick.
Sort of why I wrote some things down. I mean, first, just to sort of set the context and, kind of piggyback on what you were saying. I mean, make no mistake, this is a full frontal attack on Section 2 of the Voting Rights Act. And if Alabama is successful in this effort, it will really render Section 2 kind of a dead letter. I mean, the text might still be there, but the way to prove violations under Section 2 will basically make the statute a toothless tiger in terms of protecting voting rights and representation for black and brown people. The case arises in Alabama the beautiful, once again for their newly drawn congressional map. Despite Alabama having a black voting age population of about 27%, lawmakers only created a majority black district in one of the state's 7 districts. That represents about 14% of the state's 7 districts. The plaintiffs in the case, including Evan, my esteemed colleague here on the end, Evan Milligan, the named plaintiff, they proved through several illustrative plans that it was entirely possible to create 2 majority and minority districts, majority black congressional districts. They convinced a 3-judge federal court made up of 1 appeals court judge and 2 district judges to unanimously hold that Alabama's congressional district, the plan violated Section 2. The court enjoined the plan and ordered Alabama to create a new plan, not to take any of the illustrative plans necessarily, but to create a new plan where where there's 2 in 2 districts, black voters can elect candidates of their choice. But of course, that didn't satisfy Alabama, and Alabama exercised their right to appeal to the Supreme Court, which promptly stayed the district court's decision. So for the November elections, they will be proceeding with the bad map, I'll call it. And in the Supreme Court, they're challenging, they're basically taking aim at the results test under Section 2 And the results test came in 1982 as a result of amendments that Congress made to clarify that Section 2 of the Voting Rights Act was intended not just to address intentional discrimination, but also to address voting systems, voting plans, voting practices that result in a denial or an abridgment of the right to vote, of Black and brown minority voters to elect candidates of their choice and to participate equally in the electoral process. Soon after those amendments, you had the seminal case of Thornburg versus Jingles, which set out basically a three-part test to establish a prima facie case, an initial case of vote dilution in a redistricting context under the Voting Rights Act. And the first prong of that test, how many of y'all are familiar with voting rights law? So I don't want to I don't want to speed through this if all right, so some of you aren't. Okay, so I'll go through all of Jingles. There's a three-part test. The first part, sensibly, is, and this is the point that Evan and his co-plaintiffs were making, which is to show the court that it is possible to draw a district that is sufficiently large and compact enough where to have a majority-minority population. And so that's the first test. Can you draw a district that's reasonably compact, that has a majority of minority population in it? Test number one. It's not saying you have to use that map. It's just a gateway. If you can at least show that it's possible to draw such a map, then you move to the next two steps under Jingles. The second step is to show cohesion among that minority group. In other words, does the minority group basically, do they have the same preference of candidates most of the time? That's called the cohesion step. And then step three is what's called the racial block voting. So, well, step two is often called racial polarization or racial, cohesion. Do the minority voters vote the same way? Step three is, do the majority voters vote as a block, basically vote the same way in order to thwart the minority voters' candidate of choice? So 1, 2, 3, that's Jingles. Everybody's understood Jingles since 1986 when it came down. And if you pass the Jingles test, if you satisfy the Jingles preconditions, you're still not to home base. That's just the threshold that then allows the court to undertake what's called a totality of circumstances test, which is where they look at the history of discrimination in the state. There's 9 Senate factors. Somebody else can probably rattle them off better than I can, but there's 9 factors and any other factors that the court believes are relevant to determine whether, whether there has been a whether this practice, this redistricting plan results in a dilution of the minority voting strength in the particular jurisdiction. All right, so they're attacking, first they're attacking that results test to begin with. They're saying that it's not constitutional for the Voting Rights Act to address anything other than intentional discrimination. I meant to discriminate against Black people, and therefore, and you have to prove that, and if you can't, then it doesn't matter how we got to this decision as long as you can't prove that it's non-discriminatory. They want to attack the results test, which was the whole point of the amendments in 1982 of the Voting Rights Act. Then they want to attack Jingles 1, that first precondition, by saying, the way that you draw the map to show that you can get to another majority-minority district, the way you do that, you can't consider race. You can only consider so-called traditional redistricting considerations. You know, have you avoided incumbents? Is it compact? Is it contiguous? You know, are you adhering to, does the map sort of make small changes to the previous map? You know, preserving the core of districts, that kind of thing. If you can get, you know, if there's political considerations, like avoiding incumbents, like not, you know, pairing incumbents together, those type of things. If you can do that and hide your eyes about race and then uncover and say, oh, wow, there's another district. There's another majority-minority district. That's amazing. I guess we got to think about it now. That's essentially the argument that Alabama is putting forth. I don't want to, I mean, I can go into my second spiel, but
there will be more. There'll be another round.
yes,
So
okay, so I'll pull up.
Yeah.
But it's not a surprise. That's my preview.
yeah, that's a really good preview. I'll just add on to this. So, as by way of background and why I think that you're gonna see in my questions that I'm a little pessimistic about the outcome of this case. Why I think that Alabama is likely to prevail. At the district court, there was, I think, one Clinton appointee on the panel and two Trump appointees. And they went through all the Jingles preconditions, they went through all the test, and they said, yeah, this isn't even close. You have to draw another district, another black majority district. And the Supreme Court looked at this not even close case from a conservative panel, and they not only agreed to take the case, but they put that decision on hold. They wouldn't let even one election go by with a second black majority district. So that's why I come to this pretty pessimistic. I think that for many years now, there's been a movement on the right to implement this. I really liked this analogy, sort of like blindfold test, to substitute that in for any consideration of race. So. So that's sort of where we're at now, and this argument will be in, is it next week? On the 4th.
Next week, the 4th. Yep.
Yeah.
Terrible Tuesday. I mean, Tuesday.
Just a regular Tuesday.
Just a regular Tuesday.
All right, I didn't know what order we'd be sitting in, so I prepared the next question for Birchall, so we're gonna jump around. I would really love to hear you talk about the importance of Section 2 of the Voting Rights Act and what it would mean to roll back these protections. And specifically, like, what would it mean if you can't win, or it's much harder to win a vote dilution case?
Sure. And I guess to answer that question, I'll start by looking back to Section 5 of the Voting Rights Act, which was a critical provision that existed and was in place and enforceable until 2013. That provision applied to states and jurisdictions with a history of discrimination and required that they obtain pre-clearance or pre-approval for any voting changes. Now, that provision was put in place because of the practices of these states with a history of discrimination and applying and adopting laws that were designed to deny the right to vote, and the impossibility and difficulties that the Department of Justice faced under the 1957 and 1960 Civil Rights Act to litigate against these practices. What they found is that they litigated against these practices, and what the state or jurisdiction just ended up doing was adopting a new law that had the same effect. So what they did was adopt a Voting Rights Act, which had the pre-clearance provision, and that provision was extraordinarily successful in increasing turnout and registration, and ultimately struck down in 2013 because the court said we're good enough. We're good to go. We don't have to worry about what's to come. We've reached a point of equality in voting that we don't need this provision anymore. But they told us that Section 2 is available if the need arises. Well, it doesn't seem that that will be available for much longer. I agree with Berna in terms of the future of Section 2 is in doubt, expressed by the willingness of the court to take on this case in the way that they did. Now, Section 2 has been an important provision in that it applies to states that don't necessarily have a history of discrimination. It also applies to states for which different practices, including qualifications or redistricting plans, make it through the pre-clearance process. They could still be challenged under Section 2. And Section 2 of the Voting Rights Act is a helpful backstop, not as helpful as Section 5 was, but a helpful backstop nonetheless to prevent against vote dilution practices. How Section 2 has traditionally been applied is in a way to ensure that African Americans and other minority groups have an equal opportunity to elect their candidate of choice. That is the language of Section 2. That has been the focal point. And to enforce that goal, courts have reviewed practices under the tests that have been described, Thornburg v. Jingles and the Senate factors. Now, without Section 2, in a world in which Section 2 doesn't exist, or a world in which Section 2 exists according to the terms of the petitioner, or according to the terms of, the petitioner, the petitioner, is one in which, so long as a state provides equal opportunities to vote, you're good. It doesn't matter whether those equal opportunities to vote are provided in a redistricting map that provides those racial minority groups with limited opportunities to influence elections. As long as they can vote, we're basically good. So what does that mean? Well, that means a rollback for many of the gains that have been made under the Voting Rights Act that have ensured and provided for an integrated legislative bodies. Without the opportunity to elect candidates of choice for racial minority groups, given the degree of racially polarized voting that exists in many states throughout the country, there will be limited to no opportunities for racial minorities to elect candidates of their choice. And as a result, we're going to have an increasingly white legislatures, increasingly white at the state and federal level. We're going to have diminished opportunities for African Americans and other people of color to represent their communities in states throughout the country. And the results are going to be quite traumatic from the perspective of the multiracial democratic project. And so I worry about the future of multiracial democracy without Section 2 of the Voting Rights Act, because it's the only key backstop that remains for protection of that goal.
Thank you. I'm going to go to Evan over here on the end. One of the things that I think we don't talk about as much, or kind of gets lost when we talk about analysis, is the actual harm that people face when they don't have the political representation of their choice, when they aren't able to elect people that really are actually accountable to them and represent them. And you live in Alabama, and you're the plaintiff in this case, one of the plaintiffs. Can you talk about the people who are affected by this case and what it means to have unequal representation in Alabama and what an adverse ruling would mean?
Sure. Thanks for having me also. And I want to acknowledge two of the other plaintiffs, Letitia Jackson and Captain Shalila Dowdy, sitting over here to my left. So for us, this case really boils down to, the theme of leadership development and also representation for the Black Belt. The Black Belt is the central part of Alabama. The soil was rich in the 19th century or 18th century, conducive to plantation economy. Lots of enslaved people were brought there to work, and their descendants still live there today, who are, our relatives, our friends. So that term Black Belt both refers to the color and the texture of the soil, but also can be used colloquially to refer to the people living there. It has the highest percentage of concentrated Black communities in the state. And so, but you have beautiful, rich language, religious traditions, folk art traditions, obviously political leadership coming out of the Black Belt historically, as far as Representative John Lewis and Coretta Scott King, so many people that have helped change the world many times over. And then it's also a place that's been stifled by generational poverty for decades. And one of the key pieces of that is, how do we get infrastructure and development into the Black Belt region? We could rely on local municipalities, but if poor rural towns are losing citizens and aren't able to attract businesses moving there, then you don't have a tax base to fuel municipal-driven development, which would lead you to rely on the state if you have a state that has a sort of sociology playing out in terms of representation, like we do in Alabama, then there's less incentive for those elected officials to prioritize infrastructure development there. So that really, puts more onus on federal intervention. And one congressperson, we currently have one out of the 7 districts that really has a representative who is elected by people that live in that region. One congressperson can't single-handedly bring the sort of concerted, organized development there. That hasn't happened yet, and it's not even clear that having a second congressperson to do that. But it would certainly be a step in the direction to have more representation for that region, and more so than just the Congress people. It's the impact of the ability to choose and elect a candidate of choice on actual voters and community members. Developing the political discernment that can help voters understand, okay, where we might be factionalized at a local level, where there might be internal cliques and things of that nature at the local level for city council, county commission, certain other seats. When it comes to running and voting for a candidate for Congress, there's a different sort of political calculation that we need to make as voters, and so that can create more maturity among the people actually living in the community, and more of a sense of long-term options. And that's something that I think we really need more of in the state in order to sustain the people who have leadership potential that are actually born in these communities. When we have people like Shalila who are going off to West Point or going to colleges around the country, around the state, what is their incentive to come back if they know I could move to Atlanta or DC and go to this level of a career trajectory? If I stay here, my leadership skills get to this level, basically because of my race. So there are things in our state that disincentivize some of our, some of the people that have the most creative ideas, that have families going back 7, 8, 9 generations, but they don't see a path towards the development and their maturation as leaders within that community. So this case has the potential to definitely make that harder. But it will also, if the ruling is against us, it will create a moment that I think we'll have to figure out how to use in order to really look at the Voting Rights Act and look at, well, what else do we need and what are we prepared to do as advocates, as activists, as lawyers, to build the movement that can realize the sorts of policies that we need at the federal level and then statewide.
Yeah, thank you for that. I think about all of the myriad impacts on the local level, and it's one thing to just go cast your ballot, but if it's just like a fun thing you do, but then you never see a result, right, then just all of the harm and disincentives that that flow from that. It has to actually be a meaningful act. Samantha. We've been talking about Alabama, we've been talking about Black voters, but they are not the only voters that rely on Section 2 in vote dilution cases. So can you please talk about how how Section 2 also impacts the Native American community and what you're sort of looking at with this case?
Sure, yeah. So I do Native American voting rights. So Section 2 is critical to Native American communities throughout the country. Vote dilution, racial discrimination through vote dilution still happens today in Native communities and reservations in Indian country all over. And without the protections, without the backstop of Section 2, Natives, will have no voice. They'll have no voice in their governments. They'll have no access to resources. All of these things that Evan has talked about so powerfully. For example, in 2004, so this was this is just yesterday. In 2004, in South Dakota, the Bone Shirt v. Hazeltine case was brought, and that was Section 2 vote dilution case. Because the legislature had packed, and those are redistricting words, packed means putting the minority community all into one district, when really they could encompass a majority in like 2 or 3 districts. And they had also cracked the Native American community, and that's where you could make a majority in one, but instead you crack them so they don't have enough power to have a say in either. They had done both of these in single-member districts, which is very important because that's what Alabama is saying here, is we don't need Section 2's protection for vote dilution for single-member districts. And this was single-member districts. It's still happening. Vote dilution, even with single-member districts, is still happening in Indian country and in minority communities across the country. And just 6 months ago, the Lower Brule tribe, a small tribe in South Dakota, sued its county, Lyman County, because despite comprising about 42% of the population there, they had never elected a single tribal member to the commission, ever, because the commission is at large, which is a historic way that jurisdictions have used to discriminate against minority communities. Like, look, okay, we're at large, it's all fair, but unless that minority, if that minority is 50%, 49.9%, they will never elect their candidate of choice. So there, we looked at, of course, the first Jingles test that you have to look at. I don't know how you look at this without looking at the first Jingles step. Is the minority community sufficiently large and geographically compact to constitute a majority in a district? And saw that, yes, in a 5 single-member district, they could actually constitute a majority. It's a very compact community because they're in a reservation. They could actually encompass 2 districts. But since 1992, the commission has been at large and has continued each decennial redistricting cycle to remain at large, and argues that, well, we wouldn't be able to find candidates. Well, that goes back to, well, if it's just fun to cast your vote, there's no point. There's no point to participate if your vote is diluted and means nothing. Your vote means nothing. Why would you go vote? Why would you waste your time? And this is just talking about the vote dilution. We're not talking about the vote denial that's also so important in Section 2's protections. How do we make it to the polls? How do we ensure our vote is counted? How do we make sure that we're registered? So it's still happening today. This is not a thing of the past. It's a thing of today. In the native voting rights world, over 90% of the cases are won. 90%. If there are any attorneys in here, you know that is unbelievable. Usually your success rate in litigation is 50% at best. And that is evidence of just how bad the problem is. Without Section 5's protections, it really is like whack-a-mole. Like, okay, let's go put out this fire. Oh, we got this fire over here. And guess what? They'll do it again and again and again. Montana, we just litigated twice for the second time, the exact same, well, very similar ballot collection ban. We litigated it, won. The ballot collection ban was declared unconstitutional. They came around right after the decision in the next legislative session and implemented almost the exact same ballot collection ban. And there's nothing stopping them. It's just, okay, how much resources do we have to go over here and put out this fire? And putting out those fires, it's only because we have Section 2. We were lucky enough in Montana, they have a state constitutional right to vote, but not many states have that. And so absent that, we only have Section 2, and then we have nothing. So I'm somewhat hopeful because this case was such a straightforward Section 2 case. I mean, just like incredible record. I mean, the plaintiffs did an incredible job. The record was robust, and all of the 3 Jingles factors were met. The Senate factors were met. It was so clear that this is a straightforward Section 2 case. But in the off chance that our Supreme Court, wants to take this another route, there's serious concern for our voters, our minority voters, our minority populations, and for Indian country. For example, what if the Supreme Court says, okay, your illustrative plan at least needs to be race blind? What does that look like? The only way you can see if you have a Section 2 case is you look at race. Or, for example, if the Supreme Court says, Okay, well, if the jurisdiction has retained the core of its districts, it's not a Section 2 violation. Also problematic, reservations oftentimes predate counties. So if you think about that, the reservation and the boundaries of the reservations often predate the boundaries that were created by the counties. Reservations also sometimes encompass several states. Think of the Navajo Nation. And reservations all the time intersect with municipal boundaries, county boundaries. So if you are preserving core districts, you could be cutting right across the reservation, right across a community of interest, and cracking or packing their votes so that they have no representation. And so when you don't have a voice, you don't have access to the resources that your community, that's your gate, that's your way to access those resources, to have a voice, to make sure that your roads are paved, to make sure that you have clean water, to make sure that you have water, to make sure that you have housing, to make sure that you have economic development, to make sure that treaties are respected. We filed an amicus in this case just to, as a reminder that there are lots of minority communities around the country that depend on Section 2's protections.
Thank you. Brad, back to you. So this case is a vote dilution case about a congressional map. But I was hoping you could sort of broaden that lens a little bit and talk about, Section 2 isn't just about congressional maps, right? So what this can look like at every level of government. And also if you think there's looking at the legal questions in this case, if you see the Supreme Court sticking with the narrower question of vote dilution, or do we have a proportional baseline versus a race-neutral baseline, whatever race-neutral means. Not gonna actually validate that that's what's happening, but that's what they're calling it. Or do you see, because as some of the panelists talked about, you can use Section 2 to go after, vote denial, ID laws, or other types of laws as well. So if you can sort of just broaden a little bit from the vote dilution congressional map piece to where else this could be felt.
Okay, I'll try. I guess the one that a lot of people are familiar with, and one of the successes that they had recently in a vote denial kind of context. Remember, it's not just redistricting. It's any voting practice, standard, procedure that results in denial or abridgment of the right to vote, on the basis of color, right? So in North Carolina, they had a voter ID law that was designed to blunt the voting strength of Black people. And in fact, the Fourth Circuit Court of Appeals held in that case, as they upheld the unconstitutionality of this, or the fact that the voter ID law violated the Voting Rights Act. They said that the state of North Carolina acted with almost surgical precision to craft this voter ID law so that it has an increased impact against voters of color. And so that's an instance where it's called a vote denial, because if you can't get into, if you can't have the ID to vote, then your right to vote is being sort of denied. So they held that practice unconstitutional. But I want to sort of loop back to the other thing that you were saying too, which is this sort of idea of race blind, and kind of walk through. This is my second spiel.
Do it.
So I'm really proud of this second spiel. So
We want it.
but the idea of race blind, like this whole thing, this whole case setup, Alabama's argument, is not a surprise if you've looked at the voting rights jurisprudence, for the past 20 years, in the 21st century. because it's what I like to call the Supreme Court big lie, which is that we've overcome race. And they started this early in the 21st century, right? In Lulac versus Perry in 2006, Chief Justice Roberts, comments, it's a sordid business. It's a sordid business, this divvying up by race, as if that's like, you don't even want to you don't even want to think about it, right? And then they come along in 2007, in a school district case, where they strike down the voluntary efforts of school districts to make sure that their student populations are roughly match the racial composition of the community. And they said, well, unless it's to protect D-juries, unless the jurisdiction had a law about segregation, then you can't take voluntary efforts because, that's just discrimination in another form. The goal might be good, but it's just discrimination in another form. And here again, Chief Justice Roberts comes up with another quip. He's good with these quips. He says the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. And that's what he said that these school districts were doing just by trying to assign students in a way that makes sure that they're representative of their own community. Then you have Shelby. We talked about Shelby in 2013, where they say, like poof poof, it's done. We don't, this section 4 preclearance formula. I mean, the coverage formula is obsolete because it's not 1965 anymore, and they're not making you count jelly beans in a jar. And we've overcome. Problems remain in Mississippi and Alabama and others, but there's no denying that due to the Voting Rights Act, our nation has made great strides. And so we don't need Section 4 anymore. And we have Section 2, because that's the backup. We have Section 2 until Tuesday. And so then finally, and this is not as clear, but in 2019, last couple years ago, pre-pandemic, in the before times, they said that, partisan gerrymandering is not justiciable in federal court. You can't bring a partisan gerrymandering case. But what do we know about partisan gerrymandering? We know that the tie between race and party is significant. So it's just sort of giving states, localities another sort of tool. Oh, it's not racism. It's not like we're not trying to dilute black voters. We're just trying to, keep the Republican majority. Right? Or, we're not trying to, in the case of Maryland, we're not trying to, do this. We're just trying to create Democrats. I mean, partisanship and race have a tie. And so denying access to the courts for partisan gerrymandering in federal court is it's a step-by-step process. This is just the sort of latest iteration of the big lie, of the Supreme Court big lie, that we've overcome race.
Until Moore versus Harper, and then maybe you don't have state court jurisdiction either. I loved your spiel. It was actually the pretty much exact question I was going to ask virtual.
I'm sorry.
That's okay. I can call an audible here. But I actually had one thing that I was going to ask him, so maybe I'll ask you, and then you can weigh in, and I'll have another question for you, and it's all going to work out. So that was a really great context of laying everything out. There's two other cases that I am just curious for your thoughts here on this. To me, this case actually reminds me of two other cases coming this term, and it's actually the affirmative action cases. Because in both of those cases, the petitioners are saying, even when the goal here is to remedy inequality, you can't take race into account. And so I am just curious to hear your thoughts, extending from all the cases that you talked to, if you see that tie into the affirmative action context as well, and into this court's view of of race and like where, including voting rights, but beyond voting rights, where is this court going on race? So I was going to ask virtual that, but we can ask if you want to add on that, and then I can go to you and ask you another question too.
I feel like I've talked too much, so I'm just going to say I think it's part and parcel of the same thing. I think it is the framing of this as, we've overcome. It was bad. We have a bad history of racism in this country, but it's over now, and therefore we as a country need to get over it, right? Like you can't, like, it's race blind if you're just blind to history. It's race blind if you're history blind, because, you can say, well, the schools, just have neighborhood schools, but you ignore the fact that, you had segregation policies and housing and redlining policies that lead to where people are living now, right? And so, yeah, it's just neighborhood schools, but like, you need to consider that. I mean, and you need to consider that policies, educational inequities, funding inequities in schools might lead to, lack of preparedness, in advance things. So, I mean, it all ties in. You want to be race blind and history blind.
So I'll pass the question on to you too, if you want to talk a little bit about this court's sort of more broadly jurisprudence on race. And I would also just add into the mix, if you can talk a little bit about the 14th Amendment here and how it's being used, because the Voting Rights Act was an act to enforce the 15th Amendment. And I think, I don't have the quote with me, but I think there is a line in the latest brief from Alabama that basically says, you exceed the power of the Reconstruction Amendments if you make us use race.
Yeah, absolutely. So, thinking about the affirmative action cases to start off and the tie-in that I was describing with respect to these cases, I've always gnashed and gnawed my teeth about the diversity rationale for affirmative action. It was a rationale that was created by Justice Powell in the Bakke case, and is one that civil rights groups have had to kind of lead on and continue to advance as a way to protect affirmative action in higher education. But I've always thought that was a rather weak rationale, because what we're really trying to do and what we really should be focusing on is addressing the history of discrimination that has left African Americans and other people of color in disadvantaged positions with respect to education. That should be the focal point. But now I'm coming to the recognition that even if that were the focal point, I'm not sure it would matter. Because I think, as Brad says, the court has a view as to where we are with respect to racial equality, which doesn't seem to comport with reality. It's easy to see sort of this kind of racial equality, or put these racial equality quips out there from within the ivory tower or the courtroom, the Supreme Court, but not having experienced or connected with the lived experience of Americans throughout the country. And that disconnect between the court and the people has led to doctrine and quips that don't accord with the reality that we live. And so the concern that I have going forward is, not only will the diversity rationale go away, but also this notion that we have the history of societal discrimination or discrimination against African Americans and other minority communities matters anymore. But if they're going to get rid of that, I'd rather them not get rid of it with a quip. I'd rather them defend that. I'd rather them say, I'd rather them rationalize and explain, and where they're getting their sources from, that racial discrimination is over, that we don't need to worry about providing protections to minority, disadvantaged, marginalized, alienated communities. That's what I would like to see come out of this court. But I don't know if we're going to get that, right? I think we're going to get in the affirmative action cases, either the diversity is not a compelling rationale, or the use of race is not necessary to achieve that compelling rationale, because you could do it in other ways, so we won't get it there. And here in the Section 2 case, I don't know if they're going to full-throated declare Section 2 unconstitutional, but they'll interpret it away, and it has the same effects. And therefore, and by doing that, they can avoid, explaining why they don't think that this tool is useful and necessary anymore. Going to the 14th Amendment, what's interesting about the 14th Amendment, especially when it applies to vote dilution, is that it provides the basis for the Section 2 test. When you go back to a series of cases decided in the 1970s, beginning with White v. Register and continuing through Rogers v. Lodge with a bit of a hiccup in Mobile v. Bolton, which was overruled essentially. You have the court expressing clearly the standards for evaluating when a vote dilution claim occurs. And they're looking to, again, the question of whether racial minorities have an equal opportunity to elect their candidates of their choice. And they look to a variety of factors related to that question, but that's the core question there. And so the 14th Amendment is still, at least on the books, a tool that can be used to address vote dilution. Ultimately, we haven't had 14th Amendment vote dilution claims since because Section 2 and Section 5 have done the work. But the question is, well, when we return to a need for the Equal Protection Clause in the 14th Amendment, whether the court will enforce it in the way that it has in the past. And I fear that they won't. It doesn't seem that precedent matters that much to the court, as we saw last term. And given that precedent doesn't matter, all you have to do, and all you have to seem to do, is say that that case was clearly erroneous when it was decided, and everyone that followed that or was part of that opinion was essentially stupid. Right? If that's all you have to do and all you have to say to get rid of precedent, then I don't have much faith that those cases will still remain on the books. But it's important to reflect on how we have understood the 14th Amendment and the work it's designed to do in the past, and how far back we are going with a court that is not willing to countenance and to acknowledge the ongoing challenges that we face as a community in creating a truly equal multiracial democracy.
Yeah, I think it'll be interesting what this case does if the Supreme Court reaches the constitutional claims, because I know that the district court didn't even have the need to get to the constitutional claims, but sort of using the 14th Amendment to say, like, you're not treating white people fairly enough in this circumstance. And I also, this is a hobby horse of mine, but Section 2 of the 14th Amendment literally says you can take a congressional seat away from a state that is denying or abridging the right to vote. And it's crazy to me that they would use the 14th Amendment potentially to gut Section 2 at the same time that, in theory, Congress could use the 14th Amendment to take a seat away from Alabama because of this map.
It's crazy, and to think about that, right? And I think that what you have, and I think the mantle will be for the court, is colorblind constitutionalism, right? And so, we're all colorblind, and now government doesn't need to make any sort of race-conscious decisions because we've reached a point where we don't need to make those race-conscious decisions. So I think that will be the way, and to the extent that there's race-conscious decisions that are made on behalf of a subordinated minority group, that's unconstitutional too, because white folks have been harmed by this, is the theory at least.
Yeah. I think that, so Evan, I'm gonna go to you, and it just so happened, I guess maybe purposely or not, like, my question for you is actually following the same theme, but more from the, again, lived experience of it. And I think also the kind of, both Brad and Virgil have talked about the court's history of saying, everyone, we can calm down now, racism is over. But I think that that's definitely something that we're seeing in culture right now, and it's something that I saw this quote in Alabama's brief that basically kind of summarized this feeling, sort of asking the court to say, hey, racism is over, we can stop this now. So I'm just going to read that quote and then have you talk about how you actually experienced that on the ground. So the state of Alabama says, plaintiffs assert that white Alabamians have discriminated against black Alabamians for centuries. Of course, individual people cannot do anything for centuries. Plaintiff's narrative reduces individual Alabamians to members of competing racial monoliths and presumes that broad-brush claims about past discrimination can justify current laws that favor one race over another. So it really, to me, that phrase sounds like, Fox News, like white grievance, like racism is over and stop making me feel bad about it. But, I mean, is that what it's like in Alabama? I'm assuming that, there's a million things you've already said to the contrary, to sort of this claim that this is all about the past and we need to just move on.
Well, one of the things that the state of Alabama's attorney was trying to grill me on during the preliminary injunction hearing was this idea of really just trying to back me into a corner to admit that, how do I say this? To basically admit that if we're going, the quip from Roberts, Like, aren't we discriminating against white people by creating these opportunity districts? And one of the things that I said was, you know, within the caste system here in Alabama, you have rural white communities who live in material conditions that mirror those of their black neighbors. And when you have representatives who are sensitive to the black community, the way that they lead and the policy interests that they begin to prioritize can actually have a material impact on those white people that are adjacent to those black communities. And so I think that there's something that when the state of Alabama tries to use white grievance narratives or white genocide narratives, they always do it in a position of punching down on black people and not really with an interest in actually doing a very meticulous survey of the real material conditions of white people in that state. And so that kind of quote is just an extension of that type of logic. And one of the things that we're really concerned about is when we look at sort of the erosion of voting rights protections in the country, as we're also seeing, particularly in our state, the number of elected officials who were involved in the rally that preceded the insurrection last year. Both our attorney general, Congress people, senators who were directly involved. Like, they're not emerging from the ether. There's a political climate that is reflected by the maps that were really drawn, you know, long before 2010, but certainly that year when we look at some of the districts that have emerged, because now you have more people at the state level who can articulate and mainstream certain philosophies that prior to those districts, you wouldn't be able to get those talking points in mainstream media. And then that then impacts the discourse and the culture of the legislature or of the other political caucuses around the state. And so when we're essentially emboldening that type of culture, one of the things I'm thinking about, I would love to, you know, ask this panel and even people that are members of ACS is how do we explain this to the masses in a way that is sharper than, I would love your spiels. If we could record your spiel and like animate it and have it it would, there's like when we go out as organizers or activists or Alabama Values, my colleagues here that work in the comms hub, and we try to talk to people about this stuff, how do you, I get a minute of this person's time. So one slogan we were thinking about is one demand, two options. The demand is permanent voting rights protections for all Americans. And then an option would be a 28th Amendment to the U.S. Constitution that would do what the 14th, 15th Amendment don't currently do, and then, or pass the John Lewis voting rights bill or something comparable to that. That seems like that could work in chant format. That seems like I can easily explain that to someone if I have 30 seconds of their time. It plays well for visual, but I would need, like, we actually need these sort of conversations to flesh out what that policy package actually looks like so that it holds up under the scrutiny that you know would certainly be directed towards it if people actually begin to build movements around that.
If anyone wants to answer, feel free. I have one more question, and then we can all just talk.
Well, I'll just say that the theme, I mean, clearly is that we're still remedying racial discrimination. That is, I mean, that you have to accept that. We are still remedying racial discrimination. And for that reason, we have to look at race. We have to look at race to remedy racial discrimination, period. And, you know, I mean, just and racial discrimination happens today. It happens today. So, yeah.
Yeah, or maybe just saying, you know, yeah, I mean, if you have your 30-second elevator pitch, race still matters, right? Like, race still matters. You know, the way to stop discriminating on the basis of race is to, like, realize that race still matters, right? Like, that's the answer to John Roberts, I think.
I'll wrap up my questions portion of this with Samantha. If the Supreme Court makes vote dilution cases really hard to win. Where do you go from there when you're looking at Native communities or, all, minority communities? What tools are you guys looking at or thinking about, or how do you sort of like push forward? Which is really kind of a question that Evan is asking too.
Wow.
Just solve this for us,
I'm still
okay?
ahead and standing right here. I think we still have the 14th Amendment. So I guess just from a litigation standpoint, what we're looking at is, so we have testifying experts, and generally these are needed to be able to prove the 3 Jingles factors, specifically factors 2 and 3. And we don't separately also have consulting experts. We just have our testifying experts. But if we have to do this, and a consulting expert is someone that, just the attorneys would work with and consult with, and what we do with them is confidential. But if we have to do this race-blind thing, we would then have a consulting expert, to actually do the work and look at race and try to see how many districts can be drawn here, and then, form that out to the testifying expert. So again, it's just this oh, look, okay, this is confidential. Oh, what do you know? You found this. And that's, that's weird. It's a dance that's not necessary. These mental leaps are so obvious to me. I mean, just from the litigation standpoint, that's what we're looking at. I mean, I think we have to tell the story. I think that's what you guys are doing right now. We have to continue to tell the story. I mean, you have to tell the story of what life looks like on a reservation. The roads are not paved. There is no running water. There are 15 people in a 2-bedroom house. There are severe health issues that, to make it to the polls on top of that, to be able to cast a vote, and then to have your vote mean something for it not to be diluted, that's it. That's your voice. That's the promise of this democracy. And so, I'm just continuing to think that this is such a straightforward, beautifully litigated Section 2 case, and that the Supreme Court has to see that, but I guess we'll see what happens.
Thank you. How are we doing questions? Is there a microphone, or can people just ask? Oh, awesome. Does anyone have any questions?
Thank you all for that. I don't recall, so I'm going to ask again. What was in the plan, the Alabama plan that they wanted with that one majority-minority district? What was the racial composition of Black voters? What was the percentage of Black voters in that one district? And do you know what was determined to be the percentage of Black voters necessary to allow them the opportunity to elect a candidate of choice? I'm interested in the difference between the two.
In the map that was actually placed in operation by the state?
Yes. That
I think it's District 7, if I'm not mistaken, I believe it's at 53, 54% in the map that's currently in effect. And what would it take to actually have a vote?
Right, because I know some analysis was done because, well, aside from the fact that you could create 2 majority-minority districts, I'm interested in knowing what was the percentage of Black voters needed to allow them the opportunity to elect.
And then there was debate about this within our coalition because I think you could have a plurality at around 47%. But the population of the Black Belt is decreasing as those rural communities shrink. And so that will, 10 years, 20 years have some sort of impact, whether it plays out 1-to-1 or how that plays out with percentage of the population, we'll have to see. But that was a conversation that we had, as we were doing the organizing last year.
And the 2020, the 2020 census showed the white population in Alabama declining, as we see in a lot of these states that decided to pack voters so they could prevent the opportunity to create an additional majority-minority districts, right?
Right.
Okay.
Now, to your point, though, I think what you're implying is, could we have So what was argued in the preliminary injunction hearing was not necessarily that the state of Alabama needed to build maps that featured two Black majority voting age population districts. What the court actually held was that the state needed to produce two districts where Black Alabamians had an opportunity to elect a candidate of their choice. So if that ended up looking like two majority minority districts, or one majority, one plurality, or two plurality, the state could have come back to the court. The court gave them 14 days to draw the new map. And there was a range of different maps that they could have actually presented to satisfy the court's ruling.
And this is my last point. What's interesting is, because I worked in the state for this last redistricting cycle, there were opportunities and trainings and webinars by people all over the state teaching them how to draw plans and how to attend these hearings. Some of those redistricting hearings were not held, and the voters didn't know that they had decided to change it. But these individuals were learning how to draw maps, talking about their communities, going to their hearings, and presenting maps, which was really incredible, given that we've got these open source mapping applications where you can actually sit at home in front of your television and draw plans. And they did it, and they came out and talked about their community. So all of these redistricting principles that Bradley was discussing earlier, they were taught to these individuals, and they came to the hearings showing plans with equal population, compactness, contiguity, all, and respect for communities of interest. They did all of this, and the state was like, we don't care.
Right. Right.
There was much celebration when a Black female was appointed to the Supreme Court recently, but nobody ever mentions that there's 0 Asians on the Supreme Court. There are three African American, 1 Hispanic, several women, but 0 Asians. And in light of the fact that the affirmative action case involved, in Harvard at least, Asian Americans as the plaintiffs, students, why isn't there any discussion that there's 0 Asian nominees for Supreme Court? I know this was a Biden campaign promise, but nobody ever mentions in the media, anywhere at ACS, that there are 0 Asian Supreme Court justices. Anyone comment?
Yeah. I mean, I'll just give you my thoughts on it. I think that Asian Americans are legal afterthoughts. And what I mean by that, when you think about anti-discrimination law, you think about the Constitution, you know, Asian Americans are not front and center in the minds of those who make decisions, both with respect to the shape and the direction of the law, and both with respect to the composition of those who will make and decide the law. And so until there's a conscious effort to make those who are afterthoughts forethoughts and visible within our legal constitutional framework, I think we'll continue to have this challenge. And so, yeah, I think it's something missing. I think it's something that has occurred with respect to the Voting Rights Act and its operation, right? There has been some efforts to provide protections to Asian American and Latino communities, but those efforts have come up short often, both from the enforcement angle and the adjudication angle. So that's kind of my theory on how things are playing out.
If there was a possibility to have appointed an Asian justice in place of the last 3, I think there were many qualified
For sure.
options. I wish that had been explored and appointed.
I mean, I think it's important that the court reflect America, right? But I think that also plays into the whole conversation we're having here, because ultimately it's an issue of who is in office to appoint the justices to the Supreme Court. I mean, Evan said, yeah, anyone, an Asian American justice, hopefully would have been a better choice than any of the past three.
Well, not the past, but let's say four, before the
Before,
past.
before
Yeah.
Justice Jackson,
Yeah,
right?
right.
But I think, but the reality is, getting people in office who are, sensitive to the idea that the court needs to reflect the racial and gender diversity of the country is important, but it's less likely to happen with these sort of voter suppressive kind of measures that are the subject of Section 2 or the subject of a lot of this voting rights litigation. And it just goes back to the point that race does matter. Having diversity on the court matters. The perspective, as you mentioned, the plaintiffs in those affirmative action cases, are Asian. And so, having a different perspective on the court, I think, matters.
I guess I'll say just as a one follow-up is that you have only 9 members on the court and they have life tenure. And so you're going to have very slow turnover process. And so given the increasing diversity of this country, maybe we should rethink the composition and structure of the court. And maybe that will create more opportunities for greater inclusion on the court.
+1.
Hi, thank you for this wonderful panel and talk and questions. As someone who doesn't practice in the voting rights arena, but is very interested in, everything that you were talking about, I know, Samantha, you had mentioned that certain states have some provisions that can make cases a little bit easier to litigate. And I know it's no substitute for the gutting of the Voting Rights Act, and we don't know what Tuesday's outcome will be, but could you, each of you who are working tirelessly on this front, talk about what you would hope to see in the states at a state level, whether is it a state constitutional amendment that could help protect the access to the ballot, or is it, for redistricting, is there any mechanism at the state level? And I know in some states it's a super majority in the legislature, but in others there might be an opportunity to kind of galvanize people, thinkers, voters, activists around certain issues that could help bolster at least at the state level. What might be a recommendation there?
Yeah, absolutely. We have to head to the states, 100%. I think that's got to be it. So Montana has a right to vote constitutional provision because they had a convention in the 70s. So, it's just the history of that. Alaska has one as well. Some states have their own Section 2s or a version of Section 2. Some states have a version of like a Native American Voting Rights Act. But I think that's where we have to focus now. I think at least for the foreseeable future, that's where our energy is going to have to be, and to look at what's possible in each state. And I know that, it varies so much. That's the problem, right? But also we have to look at our on-the-ground partners and, say, where is our avenue here? Where can we build a movement? How do we get protections for the people in the state? So I don't have an answer as a litigator, but I know that in Montana, we were fortunate enough to go to the state court and not have to litigate in federal court there, and the protection was strong and obvious. And unfortunately, to be followed by another law that stripped away that right, we again litigated again, and we're waiting on the decision right now and expect to prevail there again, hopefully to not have that right stripped again. But the voters there have paid millions of dollars in attorney's fees for with the last when the session when they again restricted ballot collection. They also eliminated election day registration, and they passed both of those with money to defend them with and then they passed, I think it was like $100,000, and the bills well over 1 million. So the voters there have to see that, they are paying a huge price to defend these laws that are unconstitutional. Regardless of what side you're on there, like that's your money, those are your tax dollars that could be put to better use. So, and similarly in South Dakota, there is an insurance program that the larger jurisdictions, counties fund, and they essentially fund to defend the voting rights violations of the smaller counties. And of course, every jurisdiction needs a defense, legal defense. But at some point you have to say, well, where's my money going as a taxpayer? And would it be better spent at some education, a couple of hours of, talking to counties and municipalities and school districts and water districts and sanitation districts about what Section 2, if we have it, or, what the 14th Amendment or whatever state law requires, and ensuring that districts are drawn fairly. So.
I would just add, sort of, as we move, back to the state courts, if, that is, I think that's part of the litigative strategy, but it also brings up the importance of down ballot races at the state level, right? I mean, sometimes your state court judiciary is elected. And, so knowing who is on the ballot, who will be deciding, because the state could have a wonderful, law. Florida is a great example. Florida has, a great, a great, voting rights law. But the people who are, now, in control of the Florida Supreme Court are not likely to interpret that law in the way that's friendly to voters, even though it's a very voter-friendly statute. So sort of, again, going back to the point of these down ballot races matter. Don't just vote for president and fold your ballot up. Don't just vote for governor and vote your ballot. Know who is, know who you're electing on the judiciary, and that's crucial.
One of the things we're trying to experiment with outreach around the case is something called Power on the Line, and the website I would encourage y'all to explore is called powerontheline.org. And it's really, we hope it can be as a network of state hubs that can feed into a national coordinating structure that will plan an event that will culminate in April of next year, around the time we would think the court would still be working on, drafting its opinion for our case, to impact the tone of the media coverage during that time. There's this drumbeat now, even in the room right now, is this presence of, we're gonna lose, we're defeated, roll back, that kind of thing. When we go out to communicate to people in our communities, we can't, that's not attractive. And so if we're going to do something, if we're fine with letting go of the country, okay, I don't think anybody in this room and most of our closest friends are. And so, but how do we find something that feels authentic and organic and doesn't feel thin when we're going into communities? That really takes movement building and time. It takes deep relationships. The gentleman just kind of spoke from a place of, I feel some of my community's concerns are invisible and not even being addressed, even in this multicultural progressive space. So to be able to process those sorts of things takes time. It takes events. It takes public things that people look at and can actually see as a representation of their political values manifesting in reality. And so that's where I'm drawing hope from. I don't know if people will do it through the platform we're trying to create, but hopefully we can add our brick in that road, and then, eventually more things will emerge.
Would someone like to comment on the efforts by some people to vest voting rights solely in the legislature and removing both the governor and the state judges from the process?
Gentleman's referring to the Moore v. Harper case and the independent state legislature theory that's before the court, which is based on an interpretation of Article 1, Section 4, which says that the time, place, and manner of elections shall be prescribed to the state legislature thereof, giving Congress the authority to oversee what the state legislature does. And the argument is that, well, it only says state legislature, so therefore the court, the state courts cannot review what the state legislature has done, even if the what state legislature has done violates the state constitution. Which is what happened in North Carolina. The argument was that the gerrymandered map violated the state constitutional provisions providing for free elections. So this represents a tremendous threat. Courts are an important check in our political process. They provide checks against self-serving behavior that the state legislature is constantly engaging in its partisan gerrymandering districting process. And I think that the court, I hope, and this is kind of going along with Evan, message of hope, right? I hope that the court recognizes it as such, as a threat to the system of checks and balances that are designed to defend against abuses of power. Now, what we see here is an anomaly in the sense that the state Supreme Court, heads of the state Supreme Court in all 50 states participated on a brief that was neutral, but was also against the independent state legislature theory, because they recognize the threat that this case represents to the authority of the courts and to concerns about checks and balances and abuses of power. So that's kind of where it is. If the independent state legislature theory does go forward, what you will have is nearly unfettered discretion for the state legislature to engage in prescribing the time, place, and manner of elections, which includes drawing district lines in a very partisan and manipulative way. The only institution that could step in would be Congress, but we know Congress is not at risk of doing anything anytime soon. And we also would have the courts that could enforce the federal Constitution, but the federal Constitution, when it comes to partisan gerrymandering, has been taken away in the sense that the court has declared the Equal Protection Clause or declared partisan gerrymandering to be a non-justiciable issue under the federal Constitution. So what it would mean would be unfettered partisan gerrymandering, essentially, which would have extraordinary distortive effect on our democracy.
When I think about the case Merrill versus Milligan and Moore versus Harper in the same term, I think about sort of a 1-2 punch, because I think about, if the court, weakens Section 2, then you're going to have state legislatures that are much whiter, right? And then those are the same bodies that are then empowered with the, possibly empowered with this independent state legislature doctrine to then draw maps and set other voting rules as well. So I think of it as sort of, Milligan sort of like creates a more gerrymandered legislature that then has the opportunity to has much more control over all of the other rules of federal elections.
Just the irony and the judicial acrobatics that would be necessary, for the court that decided Marbury versus Madison, right? That it's the job of the courts to say what the law is, to then just take that right away from state courts, for no reason. It confounds the whole separation of powers. The whole, American system of government not to have the check and balance of a court system. And if you say that the state courts can't say what the state law is, that is just, while at the same time, holding out Marbury versus Madison, because at the time that Marbury versus Madison was decided, that was a question, right? Like, who gets to decide what the federal law is? And there were those who were arguing on the federal level this exact same point, that, the president should be able to say what the law is, or Congress should be able to say what the law is. And, and we decided as a country that wasn't the way to go in like the 1700s. So like, right, yeah. I do worry about that, all that to say.
We need Evan back for our ray of hope.
I know, okay. I do think that's a good point too, though. Actually, like, he does raise a good point. We can, commiserate in this safe space.
Yeah.
But I do think providing some hope.
I mean, well, as Virgil said, I think, going full independent legislature doctrine is a pretty far to go. On this case, I'm more pessimistic, but.
Yeah, it would be far to go because I don't see how you stop with saying the courts can't be involved. You have to say that the governor can't be involved. The governor can't veto what the legislature does with respect to the time, place, and manner of elections. And then you'd have to say, well, then you can't have independent districting commissions, right? In a case that you just decided 7 years ago is now overruled because we're deciding this case differently. And again, I don't think the court takes precedent that seriously, for sure. But I think that would be a dramatic step. And given how much they would have to do to get to where they want to go with respect to independent state legislature theory might give them some pause.
All right, I'm getting this. And I don't see other questions, so that seems like great timing to wrap things up. Thank you guys so much for being here.